Let's proceed. Thank you.
My apologies, Chair. You've told the Chair that by letter dated 4 July 2014, you were informed that a decision had been taken to institute an inquiry into your fitness to hold office. Correct?
That is correct, Chair.
You also told the Chair that you received a notice that the President was considering suspending you on full pay, and that was on the 30th of July 2014.
That is correct.
You took certain steps in regard to the suspension issue.
That is correct.
The upshot of it all was that you were never suspended.
I was never suspended. That is correct.
In paragraph 50 and following, you deal with your right to a fair hearing, and your statement in paragraphs 52, 53, and 54 focus on the point that really your rights to a fair hearing were prejudiced because you were not given sufficient particulars of what this inquiry was to be about.
That is correct, Chair.
So, for example, you say in paragraph 52 that you weren't given particulars of criminal convictions. You say in paragraph 53 you were not given details of the alleged comments in the media which were divisive and had the effect of bringing the NPA into disrepute.
That is correct, Chair.
And you were not given details of the alleged prosecution which you had failed to disclose at the time of your employment, correct?
That is correct, Chair.
And your view was, as placed on record in paragraph 55, that it wasn't for you to speculate about these matters, details should be provided.
That is so, Chair.
And you took action in terms of these contentions of yours, correct?
That is correct, Chair.
Bill, well,
not formal action, you communicated these.
You say you were not given clarity with regard to the media comments to which reference was made, is that right?
That is correct, Chair.
But I did read somewhere, I don't know whether, I think it was a letter that you did send to the presidency, which would be maybe in the record relating to the Corruption Watch matter or CASAC matter, where at some stage you say, if I recall correctly, although you say you don't know what media the president may have been referring to, you say, but what was said was accurate, was correct. My understanding of what you said, it's either in a letter or in an affidavit, is where you were saying, effectively, I haven't seen maybe the newspaper, if it was a newspaper, where I'm alleged to have made those remarks, or whatever the source or the medium was. But you say, but that is actually correct. Does that ring a bell at all?
It doesn't ring a bell, Chair.
It doesn't.
Yeah, but Chair, I know that what then happened is In the letter that I sent to the president, or in this affidavit, I said that I ended up speculating because I was required to respond. But to be precise, to say precisely that this is the media comment that I made, which the president is referring to as the media comment that is divisive and brings the NPA into disrepute, I expected the president to tell me which of the media reports he was referring to.
Mr. Pretorius, is the letter that Mr. Ngasana or his attorneys, I think representations that he made, is it here? Because it might be the one where my recollection or understanding at least is that he was saying, in effect, what is alleged is correct. I might not know whether this was in this or that medium, but it is true.
What is annexed as MN 5 is the draft submissions made by the NDPP to the Kasim inquiry, and a number of these matters are dealt with in those submissions. But
No,
the
this would
letter,
be-
as I understand it,
It
is
would
not,
have been,
in other words, the response to the letter at page 48, the letter of 30 July 2014, is not included in the bundle.
Not included.
No.
Yeah.
We could attempt to obtain it, of course.
I think you were, Mr. Ngasana, making representations
Yes.
to the president as to why you should not be suspended.
Yes.
I think that's the letter, because in regard to the establishment of the inquiry, you are not asked to make representations whether there should be an inquiry or not. But in regard to whether you should or should not be suspended, you were asked to make representations.
That is correct.
And I think in response, you then asked for particulars.
That is correct, sir.
Then, but you were not given particulars. And I can't remember whether you responded when you made your representations to the president, whether you had already been told that you were not going to be given particulars, or whether because there seemed to be no response from the president to you asking for more time or whatever, you then decided to make representations anyway. But I think it is in your representations on why you should not be suspended where I saw what I'm talking about. So if we don't have those here, then, but I think there is somewhere where on my reading you seem to say what is alleged is true, but you were querying, I think, maybe the medium where it might have been reported. You can't remember?
I can't remember, Chair,
Yeah.
but in the same spirit, Chair, I think the point I was making here is that that did not take away the responsibility of the president to give me particulars of what he was alleging. I may have made mention of media reports speculating, but precisely which media comment that he was referring to, it remained he was expected to tell me which one was
Yes. I
that
think
he considered divisive and bring the NPA into disrepute.
I think you may wish, as I indicated earlier on, after today, to just go back to the record of that CASAC and Corruption
Corruption
Watch
Watch.
matter, because there is a lot of material there, you know,
Yes.
and you were not, your participation in those proceedings was limited.
Yes, Chair.
other parties participated very fully.
Extensively.
But, and they attached to their affidavit some of the correspondence that the parties exchanged. And at a certain stage, the presidency submitted to the court the record of the decisions that was sought to be reviewed. And then they got more correspondence that had been exchanged between yourself and the presidency, and then there was a supplementary affidavit. So I'm raising that partly because you, out of not remembering, you might say one thing, but when you refresh your memory, you might have a better recollection of what the position was.
I tried to get the letter, so we might have it soon.
Yeah, okay.
In any event, Mr. Nkosana, you say in paragraph 56, because I did not have the essential particulars of the allegations against me, I could not say whether they were true or whether they were sufficiently serious to warrant suspension, or whether they were such that it is not possible for me to interfere with an investigation into them or with witnesses who made them. Perhaps I'm leading you unfairly, but does that correctly reflect your position?
Yes, Chair. Yes, Chair, it reflects my position. I think it's saying exactly what because I firmly believed that I was not getting a fair hearing if I was not informed precisely of what the President was referring to.
It appears that the response to your complaints by the President were to the effect that it appears apparent from your initial response that you were aware of the matters to which the President was referring, and that you had sufficient information in order to enable you to make representations. That was the position of the President.
That was the position of the President, yes.
And we'll look at the response to the notice when we get it. Over the page, you deal with the Kasim inquiry. Chair, I'm not sure that the fact that the President's complaints in the terms of reference differed from the complaints and the submissions needs to be dealt with in any detail. The fact is that that inquiry did not commence. What is of more concern is whether you require Mr. Nkosana to go through his draft submissions, because those deal in detail with many of the issues that have been discussed in evidence. Because if that is so, and if we can't just have it as a matter of record, we will take a considerable amount of time to complete that.
Well, if the submissions are here, it's not necessary to go into too much detail. It might be important to just deal with the main features and to confirm that the submissions reflect his views.
Let's first deal with the complaints you raised on page 14 and 15 of your statement. Essentially what you are saying here is that the President's complaint, as expressed in the terms of reference, differed fundamentally from the complaints that were put up to Advocate Kasim in the course of the inquiry.
That is correct.
If you can, highlight for the Chair the essential differences between the two. I'm not sure that that's a fair question to you, but in what respect did they differ fundamentally as opposed to in formal detail?
Chair, the complaints that the President had mentioned in his terms of reference, some of them when he instituted when he appointed the Kasim inquiry, he did not put them as the complaints. I think that's the point that I was making. And then I make reference to those here from page 14 to page 15. I think also page 16 as well.
Well, you can mention one or two or three fundamental differences, and then we can move on.
Chair, the complaint.
What the inquiry was required to do is to determine whether you were fit to continue in office as the NDPP.
Yes.
And was the factual basis on which it was supposed to determine that issue, were the factual basis the issue of the assault conviction and the murder acquittal and the absence of a clearance certificate? What was the context of that
Okay.
function, that brief on the part of the inquiry?
Chair, the letter that I received from the President, or the minute dated the 30th of July 2014,
Yes.
it's on page 48.
Page what?
48.
48.
48.
Yes.
In the last paragraph.
Yes, but that is the notice of intention to suspend. Here we are looking at the terms of reference as opposed to the submissions.
No.
No, the
It
last
says the
paragraph.
inquiry will examine your fitness to hold the office as National Director of Public Prosecutions, having regard to whether. So it's exactly what we are looking for. One, the criminal conviction which you possess for violent conduct. Two, reported comments in the media are unbecoming of a National Director of Public Prosecutions, divisive, and have the effect of bringing the National Prosecuting Authority into disrepute. Three, the lack of disclosure of the facts and circumstances of prosecutions which you faced are consonant with the conscientiousness and integrity of an incumbent to the office of NDP. So the factual basis for the establishment of the inquiry was it was these three grounds.
Yes. Chair.
Yeah. Okay. All right.
If I might just clarify, Chair, in paragraph 60 and 61, what Mr. Nkosana is saying here is that the terms of reference published on the 9th of February 2015 deal with the issues in paragraph 61. And in contrast to that, the submissions on behalf of the President, the Minister, filed on Monday 4 May 2015 were different to the complaints in the terms of reference. So he's comparing two different things. And perhaps if we just look at paragraph 61,
Yes.
because the letter to which we've referred was the letter inviting him to make representations in regard to suspension. And maybe that's a third difference, but not the difference
Yes,
he's referring
well,
to here.
Well, for me, it's helpful insofar as it tells me, excuse me, what the President thought as at 30 July 2014
Yes.
the inquiry would look into and on what grounds. But of course, to the extent that the same issue is dealt with elsewhere, we must look at other documents as well.
So is it correct that the terms of reference in summary referred to 2 previous separate convictions on charges of assault, referred to complaints of professional misconduct laid against you with the KwaZulu-Natal Law Society, referred to you having faced criminal charges for acts of violence, referred to your arrest and detention on criminal charges, albeit unspecified, and referred to the media statements bringing the NDPP and NPA into disrepute. Is that correct?
Yes, and any other matter.
Yes, that's important. And the terms of reference also refer to any other matter as might be relevant to the above-mentioned issues and your fitness and propriety to hold office.
That is
So
correct.
that's an open door for further allegations.
That is correct.
The complaints in paragraph 63, you summarize the complaints in the submission and you say that what was complained of in the submissions against you was firstly that before your appointment you'd failed to disclose to the President or his advisors that you had 2 previous convictions for assault.
That is correct. Sure.
That secondly, you had failed to take steps to expedite the finalization of a complaint to the Law Society by Mr. Jabulani Mchali against you in 2008.
Yes.
A slightly different emphasis from what had been raised earlier.
Yes.
And thirdly, that in your security clearance application, you failed to disclose that during 1985 you'd been acquitted on a charge of murder and that during October 2012 you had been arrested but not charged for inconsiderate driving.
But Chair, I think most importantly, what you have omitted to read is that in that security clearance application questionnaire, in answer to the following question, inverted commas,
Yes.
have you ever been convicted or are there any pending cases for a criminal or departmental case?
Yes.
Departmental case. Then, because this is very important, this is what the,
Yeah, it is important. You are right.
it is very important because the security clearance is written in this fashion. And he says that I failed to disclose this. But if you look at it, it's not
Yes, you failed to disclose an acquittal.
an acquittal, which is not what is asked.
Actually, if you had said, I was acquitted, blah, 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 anybody reading that would have said, what is this person talking about? The question was about conviction.
That's it, Chair.
Yeah.
And secondly, the same logic applies to the fact that you were arrested but not charged for
Exactly.
inconsiderate driving during October 2012.
But I think in simple layman's term, if you are arrested, not charged, you are as good as you are not convicted, you are not prosecuted.
Yes.
I mean, there is no issue. I don't know why
It
they
would
had
be
to raise-
it would be different if the question was, have you ever been arrested?
Arrested, yes. It should have been different.
And then you were also charged here with failing to disclose whether you had taken any steps to resolve your complaint against the 2 police officers who arrested you unlawfully during October 2012 for inconsiderate driving. I'm not sure that that is covered by the security clearance question either.
No, it's not.
Yes.
Not at all.
In any event, there does appear to be a difference in detail and
In
emphasis.
detail and emphasis, yes, Chair.
You point out in paragraph 64 on page 16 that certain complaints did not fall within the terms of reference. That's an analysis that one could do in due course with reference to what you say here.
That is so, Chair.
My concern, Chair, is in relation to the preparation of the submission for the CASEM inquiry. In that submission, Mr. Nkosana sets out in some detail the merits of the complaints against him. Now, the merits of the complaint against him may be relevant to a different inquiry as to whether there was merit in relying on these allegations as they were with the time lapse. And for that reason, I've taken a slightly different view from the view I had earlier, that one could just simply place them on record. So my view, subject to what you say, Chair, is that we should deal with them, albeit by highlighting. Otherwise, we can take them as read if Mr. Nkosana simply confirms. But I do suspect that if we are to go through them in any detail, in fact, I more than suspect, I'm quite certain we won't finish by 6.
The terms of reference of the inquiry was, did you say, were such that anything could be added as the inquiry was going on?
That is so.
That's how the terms of reference read?
Yes.
Any other matter?
Any other matter as might be relevant, but to the above mentioned issues. To the issues that were mentioned.
Which
the one, two previous convictions, complaints of professional misconduct, my having faced criminal charges for acts of violence, my arrest and detention on criminal charges, media statements, either issued by me or on my instruction that undermined or brought the office of the NDPP or the NPA into disrepute.
Well, there may be allegations that were made which have never been substantiated by anybody in any forum. Allegations made, there may be allegations that were included in the submissions against Mr. Nkosana, which were never substantiated by anybody or by any evidence because the Kasim inquiry did not proceed. And it may well be that, and then of course there is the issue of the settlement agreement, the terms of the settlement agreement, where the President, as I recall the terms thereof, specifically acknowledges that Mr. Nkosana was suitable to hold, as I recall, any senior public service position. I think at some stage I thought it says specifically to hold the position of NDPP.
Yes, Chair.
But I think that might be Mr. Vusi Pikoli's settlement agreement because there was some similarity between the two settlement agreements. I think Mr. Nkosana's one says any senior position in the public service. Mr. Nkosana, is that your recollection as well?
That is my recollection.
Yeah.
Chair, it's there on page, on paragraph 82.1.
Paragraph 82.1.
82.1, that's the last paragraph on page 22. The last sentence.
The source of the dispute was
The
the
last
fact.
sentence, I said, the last from the bottom line, my fitness and propriety was agreed to and recorded by the President and Minister in the settlement agreement and did not contend otherwise before court.
Yes, but what I'm saying is I seem to have, my understanding is that in your settlement agreement, what was said was that they considered that you were fit to hold any senior position in the public service, and maybe there can be an argument that any senior position in the public service would include the position of NTPP.
May I read it?
Yes,
Chair?
please, yeah.
Although it's not before you, Mr. Nkosana may recall the wording.
That's fine, yeah.
The wording that we have on record, Mr. Nkosana, which you may recall and comment on now, is the following. The President recognizes that the NDPP is professionally competent, sufficiently experienced and conscientious, and has the requisite integrity to hold a senior public position both in the public and private sector. Is that the recollection?
That is
Does
the
that
recollection.
accord with your recollection?
Yes, Chair, that was.
Yes, and the reference to conscientiousness and integrity, is that taken from the National Prosecuting Authority Act as requirements to be met by an NTPP?
Yes, it's actually taken from Section 179 of the Constitution.
Of the Constitution?
Yes.
Okay, I think that
Read
may be,
together with, I think, Section 22 of the NPA Act.
I think that may be relevant to the question you were raising, Mr. Pretorius, because if at the time of settlement, the President effectively acknowledged that Mr. Nkosana had all that was required for him to be and continue to be the NDPP, then maybe whatever he may have said or may have been said in submissions on his behalf might be neither here nor there, because it may reflect that at the time of the submissions, he may have been thinking in a certain way, but at the time of the settlement, he had a certain view, and that view was that he meets the requirements.
Yes.
It just depends whether the terms which you have read capture the requirements in the Act for somebody who is NDPP.
Yes, Chair, and we can extract those now from the National Prosecuting Authority Act. What are the requirements for appointment? We can deal with that briefly. If, Chair, the assessment that you ultimately will make of all these facts is determined by the ultimate concession that there were indeed no grounds as conceded by the President in the settlement agreement. That is one approach. But it may be of interest to determine whether the grounds raised in the inquiry were at the outset spurious or ill-advised, and that this was merely...
Yes. Yeah, maybe it's better to be on the safe side. I don't know.
Yes.
I'm not ruling.
As long as I can lay it at your door. No, Chair,
Well, the fact of the matter is, why would the inquiry be terminated if there were grounds for it to continue and make a determination?
Precisely.
Because, well, of course, I think the settlement agreement says the parties recognize that protracted litigation was not in the interests of anybody and all of that.
But is it a matter on principle that should be settled in that manner? I think that is something
that may be another question.
that was considered by the Constitutional Court. Can you settle these matters of principle?
I think it might be safer to let him deal to a limit, to some extent, with the merits on the basis that if anybody does come and give evidence, he might have to be brought back, give evidence, because if anybody comes and gives details to the complaints,
Yes,
Yeah.
indeed.
Yeah.
So if we may then go to annexure MN5. That is at page 51.
Chair. Yes, I have it.
And if we could go to page 57, paragraph 20.
I'm sorry, Mr. Pretorius. I see at page 51 what may have caused you to refer to Mr. Mdladla as Madlala. I see there's a misspelling of the surname here. So probably that's where you got that from. But it is Mdladla. But I think this is where you got it from.
Thank you, Chair. If you could then go to page 57.
Yes.
Here you deal with the merits of the issues raised either in the terms of reference or in the complaint as submitted to Advocate Kasim. Correct?
Yes, I do.
And briefly, in relation to the two convictions for assault, meaning that you are not fit and proper to be NDPP, what was your submission, briefly?
I think you said earlier on that you had disclosed the conviction for assault
Conviction.
when you applied for admission as an attorney to the Law Society.
That is correct, Chair.
Yes. Do you want to deal with that?
That,
I think you made that point.
Yes.
But I don't think that's the complete point that you made.
perhaps if that can be explained. Chair.
Okay. Okay. The conviction of assault.
Deal with the allegations in paragraph 24.
I'm sorry. Was the fact that
Sorry.
you had been convicted of assault in 1985?
85.
1985, was that a ground to render you unfit to hold office as MDPP?
Chair, I made the submission that my view was that it was not a ground to render me unfit. I say that I was very young. I think I was about 17 or 18 years old when I was convicted of those assaults. And the convictions occurred almost more than 30 years before my appointment.
When you were 17 and 18.
Yes, Chair.
And you disclosed this to when you applied for admission as an attorney?
That is correct, Chair. And I disclosed also, firstly I disclosed when I registered my articles
Yes, to the Law
to
Society.
the Law Society, and I also disclosed it when I applied
Yeah.
to be admitted as an attorney.
Was it held to be something that rendered you unfit to be an attorney?
No, Chair,
No.
no. I was,
The High Court admitted you as an attorney,
the High Court admitted
even though
me.
it was aware you had a common assault
Yes.
conviction that had happened some time before.
Yes.
Okay.
So, Chair, I think I must pause here and mention that the way these previous convictions were so old, I could not even remember the details of the previous convictions. And when I applied to the Law Society, in fact, how I also came to know that there were two convictions is when a lady at NPA, she was at the, I think she was at the risk and what unit. She then asked to conduct some vetting. And then she came back to me and said, I have 2 previous convictions of assault. And in my mind, I only knew one. And then I was worried, which one was she talking about? And it was there in my record. And it assisted me a lot because when I completed the security clearance certificate, I mentioned it. And I said, although I cannot remember what it was about, but because of the passage of age. And yes, those were, because I remember that, I think the record says in, the one that I know very well was the conviction at Kwanongoma, where I was sentenced to pay, I think, a fine of 50 rand or 30 days imprisonment. Then I paid a fine. Cannot remember whether it was 30 days, it was 30 rand or 50, but that is what the recollection that I had. Then the other one said I was convicted in Durban for assault common in 1984 or 85. I cannot remember what was that about, but it said I was cautioned and discharged.
Even today, you don't remember?
I cannot remember. Cannot remember.
It looks like to me we can't finish by 6.
There's a little way to go.
Yeah. Must you go back to Durban this evening, Mr. Ngasana?
That is correct, Chair.
Yes. Yeah, no, we can't finish.
In fairness to all parties,
Yeah.
including those who wish to justify the inquiry.
Yes, yes. So I think that therefore we may as well adjourn now, but also adjourning might be important from the point of view of affording Mr. Ngasane time to get those documents that he may wish to use to refresh his memory on some of the things. You know, do you remember whether you have got a full set of the papers that were involved in the CASAC and Corruption Watch matter?
We can provide, Chair.
Yeah, because you might wish, some of the things we might be taking long about some of the things because we have to try and remember. Whereas if you have had a chance to go through some of those things, it will be easier. We can adjourn, but whatever is left, I don't imagine we would need more than 2 hours.
No, Chair. 2 hours would do it.
Yeah, in which case we can arrange to continue on the day on which we continue. We could start earlier than normal, earlier than 10 o'clock. If we start, for example, at 9, then we would hopefully would be done by 11, and the witness for the day who would have started at 10 would just be delayed by 1 hour. That's one option. Another option is that we could even do the day's witness and then maybe start late after that witness. Maybe the morning one might be better.
Sounds so.
Sounds better. So, but it should, if possible, not be too far from now. Mr. Ngasana, do you know when you might have that 2 hours in the morning, when next you might have that time? Of course, coming from Durban, it won't be 2 hours for you. It would mean a half a day with the traveling.
Yes, Chair, I'll have to confer with I didn't bring my diary with me.
Yes, okay. All right, I think let's leave it on the basis that Ms. Ngasana, you will talk to each other.
To a date to be arranged.
Yes,
Chair,
but
may I just read for completion of
Yeah.
today, Section 9, to which reference was made earlier of the NPA Act regarding
Yes.
the qualifications for office.
yeah,
Section 9(1) reads, any person to be appointed as National Director, Deputy National Director or Director must A, possess legal qualifications that would entitle him or her to practice in all courts in the Republic, and B, be a fit and proper person with due regard to his or her experience, conscientiousness and integrity to be entrusted with the responsibilities of the office concerned. So there is a coincidence in language.
yeah, no, that's fine. Okay, I think we must adjourn, and then another date should be arranged. I hope it won't be beyond next week if possible, but it's subject to Mr. Ngasana's also practice as well and what he has in his diary. But let's try and see whether by end of this week the date has been finalized. Okay, Mr. Ngasana, so we'll adjourn on that understanding.
On that understanding.
Yes,
Thanks.
okay. Mr. Victorious will then adjourn on that basis.
Thank you, Chair.
Yes. Tomorrow, we will be starting at 8:30, and we'll be resuming the evidence of Mr. Tabete, the head of department of the Department of Agriculture in the Free State in regard to the Free Dairy matter. We adjourn.
All rise.